To our panel this afternoon, we'll be discussing the disposition of the Supreme Court towards patent and innovation law. Let me introduce this in a somewhat unconventional manner. I remember my first significant job as a young attorney was with the Senate Judiciary Committee, and we reached a point where we were drafting a report on the Court Improvements Act, which created the Federal Circuit. And we had a dilemma. The dilemma was the reason we were creating the Federal Circuit, we all acknowledged, was failure of the Supreme Court. It could not resolve fundamental issues of patent law and had left the courts in absolute confusion and chaos with wide disparity from one locale to the next, which led to forum shopping and all kinds of disquietude in the law of innovation in our nation. And it was hurting our economy. That's why one of the big reasons that the Federal Circuit came into being, but we didn't feel it was appropriate to blame the Supreme Court for creating the Federal Circuit. And so I remember us sitting in a room, and I can even remember who came up with the idea. It was Bob Fiedler of Senator D. Consini's staff. Let's call it a circuit split problem. Well, of course, circuit splits are to be resolved by the Supreme Court, but we still weren't directly questioning the Supreme Court, and that became kind of the hallmark of our effort to create the Federal Circuit, to penchant of the court to deal with patent law issues frequently and not always successfully. Let's begin with Professor Mossoff and see if he can give us some assessment of the success of the Supreme Court in overcoming its historical record of failure in patent law.
Oh, well, when you put it that way.
Well, it's a delight. Take it any direction you want.
Well, it's a delight to be speaking on a panel at the Executive Branch Review Conference. I think it shows just how ecumenical the Federal Circuit or the Federal Society is when it comes to thinking about all of the branches of the government when we're talking about the executive branch as well. It bears noting at the outset that the Supreme Court is now hearing a tremendous number of patent cases. For those who know me and my work, I do a large amount of historical work, and I can tell you the Supreme Court is hearing now more patent cases is hearing them at a rate that we have not seen since the 19th century. I mean, and realize in the 19th century, Supreme Court didn't control its docket, it didn't have certiorari yet, so it had to hear those cases. So the number of cases that it has heard in the past approximately 10 years is just a tremendous number of cases. Now, still, even when you look at that situation and you see the number of issues that it's weighing in on all matters in the patent system, both the issues of patentable subject matter, issues of non-obviousness, issues of attorney's fees, and et cetera, it's really hard to say that the Supreme Court is anti-patent, or the Supreme Court as a single institution is attacking patents. Now, certainly some justices individually are extremely skeptical of intellectual property rights generally, people like Justice Breyer. He's very, very, very skeptical of intellectual property and generally rules against patents. But it's hard to see that the other justices on the court have a particular theoretical commitment one way or the other, that they seem to be approaching the cases as they come before them. But that doesn't deny the fact that in the significant number of cases that we've heard in the past 10 years, the evolution of these cases over this time period has created a substantial amount of uncertainty for owners of patented innovation and for the firms that are developing it and commercializing it in the marketplace. And not only that, the decisions that it's been handing down that have created a lot of uncertainty and have devalued patents as assets and portfolios held by companies in the high-tech space and in the biotech space, it has fed into a policy climate that is extremely unfavorable to owners of patented innovation today. Some estimates that I've heard off the cuff is that patent portfolio values have been cut in half, if not more so, in the past several years as a result of the various Supreme Court decisions coming down that have negatively impacted the ability to obtain patents and the ability to enforce patents in courts. Now, what is going on here? If the court is not, as an institution, driven by a visceral dislike or visceral opposition to patents, or even necessarily a theoretical opposition to patents, except for some individual justices, as I mentioned, Justice Breyer, well, I think there are three factors that have been at play in the Supreme Court's jurisprudence in the past 10 or 12 years that has built up this body of work that, as I said, creates a very unfavorable doctrinal environment for patent owners. The first factor I think that has been at work is that the Supreme Court clearly is unhappy with the Federal Circuit. It clearly thinks of the Federal Circuit as uppity, as an upstart, a lower appellate court that has overstepped its bounds. Now, by the way, this isn't something that has just happened in the past 3 or 4, even 10 years. And if you go back at the turn of the century, and by the way, I love saying that now, the turn of the century, and we only mean what happened 16 years ago, not what happened over 100 years ago. The turn of the century in the Festo decision in 2001, the Supreme Court had very strong words for the Federal Circuit, saying the Federal Circuit is ignoring our guidance from this decision that it handed down just 4 years earlier in a case called Warner-Jenkinson. And so clearly in that case, even as early as 2001, the Supreme Court was very unhappy with the Federal Circuit and had the impression that the Federal Circuit was not doing its job as a lower appellate court in following its rules and following its guidelines. Now, this may this may be part of the fact that the Federal Circuit saw itself as in its birth in the legislation that gave birth to it in the early 1980s as we were the people who are supposed to step up and fix the problems created by the Federal Circuit, perhaps. But one of the factors, as I said, is that they had not liked the Federal Circuit, so they've been overturning the Federal Circuit. And in overturning the Federal Circuit, to the extent that those decisions by the Federal Circuit have been in favor of patent owners, you can't overturn those decisions without thus creating unfavorable decisions for patent owners and creating a climate of uncertainty and difficulty, both legally and commercially, for owners of patent innovation and for the firms working in the innovation industries. The second factor that I would identify as playing somewhat of a role in the Supreme Court's jurisprudence in the past, as I said, the past decades, from approximately 2006, when the court hears the eBay case, which diminished the ability of patent owners ultimately to obtain injunctions for the enforcement of their property rights, ultimately to the recent developments in the past couple of years in patentable subject matter. What you see is the court also, even outside the context of the special rules in patent law for how you obtain patents, the rules for whether an invention is new, whether it's obvious, and things of that sort, the Supreme Court does not like the fact that the Federal Circuit has created a slew of special rules for patent owners, even in areas of general jurisprudence, of general civil procedure. So what you see is even outside the cases of specific patent-specific doctrine, cases involving whether the Federal Circuit can take a case out of state court, given that the fact that the case involves a patent, even though the claim may not be directly related to it, cases involving attorney's fees, cases involving, for instance, they just recently granted cert on a case whether the Federal Circuit's rule for laches, which is a special rule which is not consistent with the rules you have in copyright and elsewhere, is enforceable. What you see is the Supreme Court constantly saying to the Federal Circuit, in areas of general jurisprudence, you are not supposed to have special rules just for patent owners that are distinct or separate from or even conflict with the rules we have for copyright owners, the rules we have for other types of litigants of private property rights or other types of private rights in the federal court system. And then last, but certainly not least, the Supreme Court, they're very smart people. And sometimes when you read these opinions, particularly in the area of what counts as patentable subject matter, whether you have an invention that qualifies for protection under the patent system, regardless of whether it's new and useful and things of that sort. So these are the DNA cases, the computer software cases and whatnot. Thank you. These are very smart people, the justices, and you read these opinions, and very oftentimes you walk away from them saying, what are they trying to do here? Their opinions are not very clear. They're very hard to ascertain as to what's happening and what the court's trying to achieve. I challenge anywhere, every year, for the past couple of years, I've challenged my students when we read the Mayo decision, which involved therapeutic testing, diagnostic testing methods, whether they're patentable or not. What's the rule here? And my students are always like, I don't know. And I was like, exactly. Well, you'll find out that there was a rule in this another decision from a couple of years in Alice. And so we now call it the Mayo-Alice test. Is that the court is sensitive to the fact that they're not specialists in patent law. They're not specialists in technology. But they clearly don't like the bright line per se rules that the Federal Circuit had been handing down in its cases. So they have stepped back and said, we want standards-based regimes in this area. And so what you see is them consistently telling the Federal Circuit, you can't have bright line rules here, either de facto or de jure, and you really need to adopt a more standards-based approach. Well, the problem with having a standards-based approach, aside from the fact that it sows substantial amount of uncertainty, ex ante for the people who have to work under those types of legal regimes, is that they're very much open to interpretation. They leave a lot of discretion to courts and to attorneys as to how to deploy them and how to use them both for or against patent owners. Well, as you may have picked up recently, there's a sense lately that patents are a problem. In fact, I think if you Google the phrase, the patent system is broken, I think you probably get about 500,000 hits minimum. And the problem is that when you create generalized standards-based regimes that are very much open to discretionary application, they become susceptible to the application by policymakers, by judges, and by others who are caught up in, frankly, what is right now I would call a moral panic about the patent system and its role in driving our innovation economy today. And so what you have is then these opinions being handed down by the court, where the court is, for instance, in the Alice case, which addressed software, the court never used the word software and never said that software is unpatentable, and yet the patent office and many judges took that as a mandate that all computer implemented technology, all software is no longer allowed to be patented in this country. And this is just a problem. And it has fed into the climate today that is very problematic for owners of patented innovation, as I said. And it's fed into, I think, a perception that the court is attacking patents, when I don't really believe that that's ultimately the intent of the court. I think it's reacting to other institutional and doctrinal matters. But the fact of the matter is that the decisions it's handing down are being capable of being used in a way that is aggressively and excessively attacking patent innovation, and it's harming our innovation economy as a result. So,
Thank you, Professor Mossoff. Good introduction here with his 3 principles. Unhappy with the Federal Circuit, no special rules and no bright line rules. Yeah. Like to talk about those, but let's hear first from our next presenter, Mr. Huston from the firm of Gibson, Dunn.
Thank you, Judge, and thanks to the Federalist Society for having me on this panel. It's a good thing I wasn't able to get a patent on the remarks I had prepared today, because otherwise I would have been able to sue Professor Mossoff for infringement, as they are in many ways quite similar. So the pattern that has arguably emerged in recent terms in the Supreme Court goes something like this. The Federal Circuit issues a decision that is in one way or another favorable to the interests of patent holders, and the Supreme Court unanimously reverses. This happened 3 times in the Supreme Court's 2013 term when I clerked for Chief Justice Roberts. So in Medtronic v. Murawski, the Supreme Court held that patent holders bear the burden of demonstrating infringement even when they are sued as defendants in a declaratory judgment suit. In Nautilus v. Bioseg, the Supreme Court abrogated the Federal Circuit's test for when a patent is indefinite The Federal Circuit had devised a test that said it would invalidate a patent only when it was insolubly ambiguous, and the Supreme Court said that's too strict, we're going to get rid of that. And then in Limelight v. Akamai, the court made it harder to demonstrate infringement, induced infringement. And as Professor mentioned, in Alice Corp v. CLS, the court unanimously held that a patentee's design for a computer-assisted process to consummate financial transactions was unpatentable as an abstract idea. So is the Supreme Court really hostile to the interests of patent holders? I should say that everything I'm saying really just comes from my own attempt to read the court's opinions and discern a unifying principle rather than conversations with justices or other clerks. But I submit that the answer is no. For a couple reasons. First, it hasn't been uniformly bad news for patent holders at the Supreme Court in recent terms. In Comil USA v. Cisco, the Supreme Court held that a good faith belief in a patent's invalidity is not a defense to an infringement suit, even though the Supreme Court had held as recently as 2011 in a case called Global Tech that a good faith belief by a defendant that his conduct did not violate the patent is a defense. And then in Teva Pharmaceuticals v. Sandoz in 2014, the patent holder prevailed when the Supreme Court held that the Federal Circuit should have reviewed a district court's factual determinations regarding a patent for clear error. So, as I read these cases, what comes through is really, as I think Professor Mossoff alluded to, a hostility to the notion that patent cases deserve special treatment. So consider Nautilus, again, which rejected the insoluble ambiguity test for indefiniteness, alongside Teva, which is another case about indefiniteness. The similarity in both cases is the Supreme Court's rejection of a special test. Indefiniteness is a very tricky concept, and that's a pretty vague statutory standard. The insoluble ambiguity rule was, I think, an understandable effort by the Federal Circuit to bring clarity to that standard, albeit one that was favorable generally to the interests of patent holders and thus to the much despised so-called patent trolls. But the Supreme Court's opinion suggests that a concern that this bright line standard, even if it has the virtues of being predictable, would produce incorrect results in a non-trivial number of cases. And similarly, the more searching appellate review standard in Teva gave less deference to district courts than would normally exist in other appeals. Now that serves one of the purposes of having the Federal Circuit in the first place, as Judge Rader alluded to, which is a uniformity in this area of the law. But the Supreme Court rejected that too. I think you can add to this pattern two other decisions from the 2013 term, Octane Fitness and its companion case, Highmark v. Allcare. The patent statute allows attorney fee awards for the prevailing party in, quote, exceptional cases. Rather than leave it at that and defer to district courts, the Federal Circuit had devised various tests in order to help sort of give color on that statutory standard. Highmark and Octane rejected these tests and said the test is just what the statute says it is, exceptional cases. No more, they denied that these other tests were helpful. And the court said awards of attorney's fees should generally be left to the discretion of district courts. I think these decisions echo what the Supreme Court has in some ways been saying for years, going back to cases like eBay v. Merck Exchange, which had held that when a patent case comes and a party seeks a preliminary injunction, we use the general four-part test for preliminary injunctions rather than any sort of special rule. I do think it would draw the wrong conclusion to say that the Supreme Court mistrusts the Federal Circuit, as Professor Mossoff suggests, or is favorable or not to the interests of patent holders. Instead, I think these cases are better explained by the justice's instinct that patent cases are really just like any other type of commercial or property dispute. They should be litigated pursuant to the statutory standards as written, without a thumb on the scale, one way or the other, and following ordinary rules of litigation and appellate procedure. And I don't think this instinct should be surprising. As Professor Mossoff suggested, the justices are not patent experts or specialists, and they don't approach patent cases with any special lens. Their law clerks, too, have often virtually no exposure to patent cases when they come to the Supreme Court, because most of them focus on public law matters in law school, and then they see virtually no patent cases in their prior appellate court clerkships. Those factors can create a steep learning curve when trying to understand the dynamics in patent cases or their potential effect on innovation, a concept that is widely disputed and important. And also the Supreme Court bar, which is those very few firms that the Supreme Court hears from repeatedly on the wide range of issues that come before it, often end up on both sides of this case. For example, my firm Gibson Dunn represents both technology companies that often are the target of infringement suits, and also pharmaceutical companies, many of which are patent holders. The Supreme Court is certainly aware of the fight that exists over whether patent trolls are a problem, what is the effect of the patent system on innovation. It gets briefs about those issues in every case. The opinion in Octane acknowledged it. That may have been the first time that it had been come up in a Supreme Court opinion in a serious way. Justice Breyer referred to it at oral argument earlier this year. But even amid that fight, at the Supreme Court, patent cases are just virtually never seen as ideological. So any sort of intuitions that the justices might have about those sort of issues, at least thus far, really haven't come into play. Under these circumstances, it seems likely that the justices will tend to prefer litigation procedures with which they are already familiar. Deference to district courts on factual questions, which was the rule that the Supreme Court adopted in Teva, and deference on balancing judgments, like when attorney's fees are appropriate. That was the rule adopted in Highmark and Octane. Those are time-honored practices in federal litigation. They likely strike the court as eminently reasonable and things that shouldn't be disregarded lightly for patent cases. The court, as Professor Mossoff said, also very much does appear to disfavor bright-line rules out of a concern that those, even if they provide additional guidance and clarity, they will freeze the law in a way that is problematic and thereby generate incorrect outcomes. Even when the statutory standard is so vague that achieving consistent application is difficult, such as when the statute says that a patent is not available for something based on indefiniteness, the Supreme Court seems to believe that if a further clarification of the statutory standard is called for at all, it is the Supreme Court's job to create it. The Supreme Court seems to think it is not the job of the lower courts, and particularly not of one lower court without the wisdom that sometimes comes as multiple circuits struggle over an issue. So my intuition about how the Supreme Court just favors the procedures with which it is most familiar could be tested this term in Jeff Wall's case, Stryker v. Zimmer, which he's going to talk about more. The patent statute allows district courts to give enhanced damages to patent holders who win infringement suits. The Federal Circuit has long had a rule that significantly narrows the availability of enhanced damages. Jeff's brief in Stryker argues that that case is just like Highmark and Octane. The Federal Circuit has committed the same sin. It's impermissibly put a thumb on the scale, and one that makes it harder for victorious patent holders to get enhanced damages. Gibson Dunn filed an amicus brief on the other side of that issue, but I didn't work on it. And though in general I share my colleagues' intuition at Gibson Dunn about the ability of aggressive patent holders to disrupt innovation, and even when they don't, to massively increase innovation's costs through litigation. But if my assessment of the Supreme Court's recent cases proves correct, it wouldn't surprise me at all to see Jeff win that case, for the court to wipe out the Federal Circuit's rule and hold instead that without further statutory guidance, enhanced damages are simply something that should generally be left to the discretion of district courts. So in summary, the recent jurisprudence suggests to me that attorneys litigating patent cases in the Supreme Court should not argue that their cases or their issues are somehow exceptional. Instead, the wiser course is to attempt to convince the Supreme Court that a ruling in your favor is most consistent with general principles of statutory interpretation and litigation procedure. Thanks.
Before we go on to Jeff, I'd like to get both Adam and Michael to just respond briefly to one point. How faithful to the statutory language has the Supreme Court been in patent cases? Adam?
Well, I think it's the classic professor answer is, it's been faithful when it's been asked to apply the statute, and it's been faithful when it's been asked to apply several hundred years of judicial interpretation of the statutes, because something because the fact of the matter is that much of American patent law is judge-made law. It has been from the very get-go, starting with the very first Patent Act of 1790, which was, I think, a page and a half long, and then with follow-on enactments in 1793, 1836, 1870, and then 1952, what you have are generally framed statutes, and then the courts have then set forth substantial numbers of tests and underlying subtests and requirements. And then, as you see in this pattern, every 50 or 60 years after 1783, the Congress has gotten back in the game, has codified some of the tests, has overruled other tests, and has left some standing. So, for instance,
where do you find in this statute any reference to natural law, natural phenomena, or abstract concepts? Where do you find in the statute anything about inventive concepts and departure therefrom? They're supposed to be in 101, which doesn't have any limitations at all. Can you go on with your answer in light of that?
Yeah, I mean, those are just judicial constructions of statutory language, just occurs everywhere else.
What statutory language is it construing?
Judge, let me finish for a moment. So I feel like I'm back in court. So I mean, you won't find in the statute the 8 factors Wands test for determining what counts as a disclosure under Section 112. But nonetheless, that's the Federal Circuit's test for determining that. So one could ask the same question: where in the statute are those 8 facters? So yes, I mean, under every statute, you have language that the courts have to construe, and then they create subtests and additional interpretations. Now, we are friends and allies on this. I am not a fan of the U.S. Supreme Court's 101 jurisprudence, just like I know that you are not as well. And I think that there are lots of concerns with it. I filed an amicus brief in support of a cert petition in a very important case called Sequinom, asking the Supreme Court to start to apply the exact same type of standards that it applies in other areas of the statute, such as the identity requirement that it is applied under novelty analysis under 102 and the invention as a whole test under 103. You won't find identity in 102. You do find invention as a whole in the statute under 103. So you have a mixture of judicial constructions and direct statutory language, and that's just the state of the patent law. And when the court gets it wrong, then the hope is to go back to the court to try to convince them that they've gotten it wrong. And if they haven't, then we always have the option to go to Congress. And it looks like we may have to do that in 101 if they don't fix the problems that they've created, at least with Sequinom.
Michael.
I guess I would say that from my perspective and in my limited experience, the Supreme Court is more interested in process than in substance. And that, it should be said, is true not just when it comes to patent cases, but really in cases more generally. The phenomenon that we have seen and that I talked about in some of these cases where you have a particularly amorphous statutory standard, lower courts are trying to build on that with a rule that creates more predictability. That's not unique to patent cases. It happens in all sorts of other areas, particularly securities fraud cases is a great example where you routinely see lower courts say, hey, there's a big problem with stock drop suits, for example, and we need a test to sort of sort out the good from the bad. And when those cases have come to the Supreme Court, they have not infrequently rejected those lower court attempts to add further gloss and said, no, just do the statutory standard, don't create your own. So I think they are less interested in getting any particular case right about whether a patent should issue or not than they are in creating the rules by which they expect, especially the Federal Circuit, but district courts obviously as well, to adjudicate those types of claims and the procedures that are going to govern. So I think that is more often their focus.
Jeff, I think we're on to you.
Thanks, Judge. It was nice to see the academic on the panel have to face a hot bench for a change.
It was fun.
But,
by the way, he didn't do very well with the question either.
Look, thanks to the Federalist Society for hosting me, and it's an honor to be up here with these 3 folks. I agree with Adam, and I don't think it's really disputable that the Supreme Court has now an unprecedented interest in intellectual property issues. There are already 3 cases for next term. There's the SCA hygiene case on latches in the patent context that Adam mentioned. There's the Samsung Apple case on design patents, which is extremely important, and the Star Athletica case on the copyrightability of features of useful articles in the copyright context. Now, 3 cases may not seem like a lot, but I looked this morning and I think the court's only granted 12 cases for next term. So you're talking about a quarter of the court's current docket. Now, certainly part of that is that IP cases have not tended to divide the court along ideological lines, which makes them particularly attractive for a court that is right now shorthanded. But I think even apart from that, there's just no denying that the court is more interested in IP issues than it used to be. And so, the first question is, well, look, why is that? Adam talked a little bit about the greater interest, and Michael talked a little bit about how they're, what's driving the court's results in these cases. But why is it taking more of them? I think there could be a number of different reasons. One is that the cases are extremely important to businesses and the economy, and you have a very organized section of the bar that is trying to bring these cases to the court's attention. I think they're increasingly the subject of a very active legislative and policy debate. I take the shuttle at Reagan, and when I get off in the B terminal and I walk down the hallway, there are huge posters or ads on the wall about patent rights. And this is something, you see the ads on television, it is now an issue in public discourse in a way that it wasn't 10 or 15 years ago. And look, the cases are also often about statutory interpretation, whether it's the Patent Act or the relatively new America Invents Act. And statutory interpretation is the bread and butter of what the justices do. And I don't think we should find it all that shocking that they've decided to wade in these cases and try to interpret these statutes for themselves. Now, the question of what kind of a job they're doing, whether they're acting consistently with the text, I'll tell you between now and the end of June when I get an opinion in Stryker. But I want to sort of focus on one other reason, which I think is a loss of the view at the court that the Federal Circuit has a caretaking role different from other circuits. And so I clerked almost 10 years before Michael back in 04, 05. And at the time, intellectual property was not as central to the court's docket as it is now. I could not personally remember any IP cases from my term, so I went back this morning and I looked, and I found 2, which I did refresh my memory a little bit. One was KP permanent makeup in the trademark context, and one was Merck v. Integra, which dealt with the clinical safe harbor in the Patent Act. And I don't want to diminish the importance of either of those cases. They were important in their respective fields, but I think it's fair to say nothing like an Alice or a Samsung. And more importantly than that, I think there was just, at least I had the sense, I think other clerks had the sense, that the justices, all things considered, preferred to leave patent issues to the Federal Circuit, both as a matter of expertise and frankly, relative interest, in a sort of benign neglect. I'll be curious to see what Michael thinks of that, and I was hoping that John would be here because he clerked before I did. And then the question is, okay, well, what changed in the last decade? And I think right around the time I clerked, it began to change, or at least I want to focus on that newer period. Delegation works well when you are reasonably sure that the caretaker is doing as well as or better than you would if called upon to perform. And I think there in the mid-2000s in a series of cases, and Merck v. Integra was one, but there were a handful within only a couple of years of each other. eBay, Illinois Tool Works, Microsoft, KSR, MedImmune. In a 3-year period, roughly, the Supreme Court reversed the Federal Circuit in each of those cases in a unanimous or near unanimous decision, 9-0, 8-1, 8-0, 7-1. And I think out of that wave of cases came a growing sense that at least the justices believed, rightly or wrongly, that the Federal Circuit's specialized expertise, particularly in patent law, but maybe in IP generally, was both a help and a hindrance. And it might be causing the Federal Circuit to see intellectual property as more different from other kinds of property than the court believes that it is, and to see IP litigation as more different from other kinds of litigation than the court believes that it is. Now that's a pretty fundamental divide, and I don't want to, I think it's kind of beyond the panel to tackle whether the court is right or wrong about the differences between IP and other kinds of property. I'm only trying to suggest that I think a divide developed between the court and the Federal Circuit that explains much of what has come later. And the really interesting question is the court right in wanting, in its impulse, as Michael says, to want to shoehorn IP law into existing doctrines, or is the Federal Circuit right to believe that some of those doctrines don't fit the field? But if I'm right that this divide developed, I think it weakened the rationale at the court for treating the Federal Circuit as a gatekeeper for intellectual property law. Add to that, as the judge says, that the rationale for the Federal Circuit was to eliminate circuit splits, but you have a court that is itself deeply divided on some fairly fundamental questions in IP law. In Cuso, one of the cases I'm going to talk about, the Federal Circuit was 6-5 en banc. In SCA Hygiene, which is the Lachey's case that's coming up next term, again, 6-5 en banc. To take another example from Cuso, there are actually two questions. One in Cuso has to do with judicial review and whether the decision by the agency to institute one of these proceedings that I'll talk about, whether that decision is reviewable in court. And the Cuso panel, looking at the language of the American Invents Act, said no. By a 2-1 vote. A divided panel of the Federal Circuit, then looking at virtually identical language in a parallel provision of the Act, came out the other way, 2-1, and said it was reviewable. And then a third divided panel of the Federal Circuit declined either to reconcile the confusion, or subsequently the court declined to take it en banc. For that it makes interesting fodder for folks like Adam, but for people like Michael and me, it's a disaster. You don't have any idea what the rule is, what to tell clients about their exposure to risk, or how to brief issues. Whether the panel, any given panel, depending on its composition, will view those issues as properly before the court or not capable of judicial review. So I think part of what's driving it, at the same time that the court is getting skeptical about treating IP differently, is you have a lack of agreement in the Federal Circuit on some fairly fundamental questions, and that triggers Supreme Court review for all the same reasons that circuit splits do, which is you have very smart, accomplished, experienced judges looking at questions and coming out to deeply conflicting views. Once the court begins taking the cases, then Michael is right. It's not hard to figure out what will happen. It's a generalist court, and they'll see the cases through a generalist lens. And the natural tendency for the court will always be to try to fit it into the existing doctrines they know. So you think about it in a whole slew of recent cases. In Teva, they'll say that you ought to review factual findings in claim construction the same way that you review factual findings in litigation generally under Rule 52. In Octane, they'll say you ought to treat attorney's fees in patent cases like attorney's fees generally. In B&B Hardware, they'll say you ought to have the same preclusion rules that you do in other kinds of administrative proceedings. And of course, in eBay, they'll say you ought to use the same 4-factor test for injunctive relief. And why? Those rules are familiar to them from these other contexts. Once the court begins taking these cases, there shouldn't be any surprise that it moves in the direction of the doctrines and the rules with which it is familiar from other contexts. It would be almost surprising if they didn't. The interesting question here is, I think Michael and Adam are right, that for the most part, this has not been driven by any theoretical commitment on the pro-patent, anti-patent side. It has to do more with a desire to exercise greater oversight over the Federal Circuit. But I think the question is that starting to change? As the court takes more patent cases and sees briefs on both sides typically amicus briefs, but sometimes party briefs, like the ones the excellent briefs that Gibson submitted in both of the cases that we handled this term, taking sides on this policy debate. Do the justices start to develop commitments in that debate? How long can you reasonably expect them to remain neutral? And in what I have seen in the last term or two, I think the questions, not just from Justice Breyer, but from others, are getting more pointed on both sides. And so, and I want to put that in the context of a couple of the cases this term, just to bring you up to speed. But I'll say, I think that's, again, another interesting question. As you're watching these cases, at what point do we think the justices come off of the sidelines and do begin to take sides in the policy debate about whether we have too many bad patents? What do we think about so-called patent trolls? How much should we be encouraging innovation? And where is the right place to set that balance? And whether they're off the sidelines yet, I don't think we can expect them to remain there when, again, these cases are now starting to take up a really significant percentage of their docket. So just to quickly turn to the cases this term, there were two patent cases, Stryker and Cuso, or sort of what I think of as the old world and the new world. Stryker is about the traditional model for patent litigation under the Patent Act, and Cuso is about the America Invents Act, which was passed in 2011 and which I think has radically reformed certain parts of patent law and patent litigation. And I should say up front in disclosure that Sullivan and Cromwell was counsel to petitioners in both cases. So I'm biased, but I'm going to try to set aside my biases, and Michael and Adam can correct me if I'm wrong. And so on Halo and Stryker, I mean, Michael, I think, set it up exactly right, which is, there is a statute that says in patent infringement cases that a district court may increase damages up to 3 times the amount of actual damages. It can grant an enhancement. And the statutory language just says may. It's just discretionary. It doesn't contain any limitations or restrictions. And so the question is, what's the right test for a district court in deciding whether to grant an enhancement? And look, our take on it was pretty simple, that it's a replay of Octane and Highmark. In Octane and Highmark, you had another statute that we said was, or that the party said was about discretionary remedies. The Federal Circuit had grafted on a fairly restrictive 3-part test, and the court wiped that away and said it's discretionary, that's what the text of the statute says, and there isn't any basis for this fairly complicated framework that the Federal Circuit has set up. So, I think obviously Halo and Stryker were framed by the petitioners as a replay of Octane and Highmark. But I do think the case is sort of most interesting as a study in how law develops, right? The judge asked Adam, well, what do you do with the text? I mean, the text of the statute just says may. Textually, it doesn't provide any guidance to district courts. Now, for a very long time, starting in about the mid-1800s and really building up through about the 1960s, lower courts have been fairly uniform in saying you could get enhanced damages only if you were a willful infringer, and by willfulness what the courts meant was something north of negligence. You couldn't get an enhancement merely for negligent infringement, but if you were something more than negligent, you could be subject to an enhancement, and there were various factors that the courts looked at. Now, that's not sort of in the text of the statute, but it was a very well accepted judicial gloss on that text for a very long time. The Federal Circuit in a early 80s case called Underwater Devices lowered that bar to negligence. And then, I think, sensing that the court had lowered the standard too far, really raised the standard in a case called Seagate and put in place a fairly restrictive standard. Now, Seagate was an understandable response in the sense that enhancements had become too easy to get. And in that sense, I think folks who were wholly critical of the Seagate test on our side of the litigation were not being entirely fair. Seagate was a response to a perceived problem, but it was a problem that, at least in our view, the Federal Circuit had created by not being sufficiently attentive to history. So I will say, I think I'm a little bit with Adam on this one, that the text of these statutes does not always provide a guide. There are other interpretive guides that courts have looked to, including history, and I think at times the Supreme Court believes that the Federal Circuit has not been sufficiently attentive to those, and I don't think it's always an adequate response to say, where is it in the text? Because the text of these statutes is simply not sufficiently definite to provide guidance on the full range of specific questions that come before courts. So, look, we'll see in Stryker what happens. Back to an oral argument, justices asked very pointed questions on both sides about making it too easy for patent trolls to get enhancements, and making it too easy for people to infringe and only have to pay actual damages, which would give them every incentive just to roll the dice, infringe, and enter into litigation. And so, how does the court resolve those competing concerns? Where does it set the bar? That'll tell us whether and to what extent patents are under attack in the court. And then just a brief word on the Cuso case, because I think in some sense that may be a better test. As everyone up here knows, the AIA creates various kinds of post-issuance review proceedings in front of the Patent and Trademark Office. So instead of going to court to challenge a patent, you can go in front of the agency, and the idea was that that would be a faster and cheaper way to get a determination on the patent. And the question has come up, well, how should the agency read the patent claims? Should it read them like district courts do and give them their ordinary meaning? Or should it give the claims their broadest reasonable interpretation? Now, of course, in the way that the agency does in examination and re-examination proceedings. Now, of course, if you read the claim, the more broadly you read the claims, the more prior art you're going to pick up, and the more likely it is that the board is going to cancel the claims. Now, I think if Michael's thesis holds, we'll prevail, because I think the court will want agencies and courts to be construing patent claims in the same way, to cut down both on different outcomes and what I think is fairly substantial unfairness to patentees. If the court, though, wants the PTO to cancel more claims than courts, either out of a fear of patent trolls or a belief that we would be better off with fewer patents on the whole, then I think the government will win. And that's why I say in some sense Cuso is a more straightforward test for whether patents are under attack in the court, because whether or not they're under attack there, I do think they are under attack in front of the agency in these new post-issuance proceedings, and Cuso is going to be a pretty good test of whether the court is willing to sign off or whether it is skeptical of that regime. Welcome. I'm glad you made it.
Our last speaker is Professor Duffy. Let me try and give you a 3-sentence summary. I think our colleagues have been unanimous that the Supreme Court's not hostile to patents, but that they are unhappy with the Federal Circuit, that they are unhappy when the Federal Circuit applies special rules for patent law rather than a more generalist approach, common law approach, if you will. And there's an apprehension that the Federal Circuit's predisposition towards bright line rules could also be interfering. We talked briefly about faithfulness to the statute, and the answers we received were that, well, the statutes are broad and they're fairly interpreting them. You may proceed.
Well, I agree that the patents, generally speaking, are not under attack at the Supreme Court. I think the most significant decision in the last few years that sort of demonstrates this is the Comil decision, Comil versus Cisco. I'm sure, again, I had to be across town because there was a congressional hearing about overruling something called Chevron, which I would love to see.
How'd it go?
Well, pretty well, I think, hopefully. But so I'm sure people made this point before, but Comill is a decision where the Supreme Court overruled the Federal Circuit in a pretty strongly pro-patent direction. And I think that if that case had gone the other way, patentees would have been much worse off than they were with the Supreme Court decision. So I think that's actually a very positive sign. Teva, technically, the Teva versus Sandoz was also technically a victory for the patentee, even though on remand at the Federal Circuit, they got nothing out of that victory because the Supreme Court reaffirmed their prior result. Pardon me, the Federal Circuit reaffirmed the prior result under the new Supreme Court test. But it still shows, I think, that the Supreme Court is not completely hostile to patents. Kapos versus Hyatt from a few terms ago was another case where the Supreme Court affirmed a relatively pro-patent decision. And even in the Limelight versus Akamai decision, where the Supreme Court did reverse what was, I think, at least sort of a partial victory for patentees, they hinted very, very broadly that while the Federal Circuit's approach was not the right approach, they hinted very broadly that there probably was another approach that patentees could win under. And on remand, the Federal Circuit, in fact, adopted something like that approach to create a victory for the patentee. So I don't think that you can generally say that the Supreme Court is hostile to patents, with one exception. I think that patentable subject matter cases are something that are a real threat to a huge section of patents, and can really destabilize the entirety of the area. The patentable subject matter cases are something that I think is sort of the pet project of Justice Breyer, who really reinvigorated this area of jurisprudence with a dissent from the dismissal as improvidently granted some years ago of a cert petition. And that ever since then, the court has adopted a very restrictive test of patentable subject matter. I will say I think it's a combination. The results in that line of cases is a combination of Justice Breyer's enthusiasm for that area of law, plus really, really terrible facts. Really just dead, terrible facts. And they always say that, hard facts make bad law. Well, this is a case where you've got some really just awful patents, and they were very hard to defend on any substantive ground as to why they could possibly be valid. And the Supreme Court used this one area, this one doctrine to get rid of them. We will see whether the Supreme Court, I think in the coming years, maybe even the next year, whether the Supreme Court is really wedded to the idea of striking down a lot of patents under patentable subject matter area. The Ariosa case, the Sequinome versus Ariosa case is on a petition for cert. I know Adam has written a very nice amicus brief in that case. And if the Supreme Court grants cert in that, I think it will be a real indication, hopefully, that they will be trying to retrench their one area of jurisprudence that I think is the most threatening and the most important right now in the patent area. So that's all I'll take up right now.
I'd like the panelists to respond to a Columbia Law Review article from a few years ago that was quite insightful in what it called a cultural divide between the Federal Circuit and its devotion to economic principles and the need to have certainty in making quick decisions in the international marketplace, and thus its preference for the bright line rule, as opposed to the Supreme Court's culture of making these magisterial decisions, dividing the public from the private, the collective from the individual, the vast decisions of great consequence in our constitutional jurisprudence. And the Columbia Law Review saw this cultural divide as causing a disconnect between the Federal Circuit's commercial law basis and the Supreme Court's constitutional law sandbox. Are we playing in separate sandboxes, and does that have any effect on this area of law?
Well, since I get my remarks short, I'll go on that.
Go.
I think that the Supreme Court in the patent area might have an affinity for sort of broader tests. I think sometimes that is the correct approach because even the Federal Circuit in certain areas has relatively broad approaches that do not give any kind of precision. I think the Supreme Court's jurisprudence, and indeed most patent courts' jurisprudence, with probably the exception of the Federal Circuit historically, have tended to realize that there are certain imponderables about the patent system and that therefore central questions of validity such as utility or obviousness are very hard to give a bright line test for, and each individual patent has to be evaluated on its merits. I think that the Supreme Court is bringing back some sense of that into the law. I don't think the Supreme Court is necessarily hostile to bright line rules. Some of the conservative justices are quite fond of bright line rules. I know we lost one of those conservative justices earlier this year, who loved bright line rules and said he loved bright line rules. But even he recognized that there are certain areas that bright line rules don't work very well in. So for example, in antitrust jurisprudence, what I like to call the other branch of federal monopoly law, the Supreme Court is not a fan of bright line rules in that area, and I don't think the Federal Circuit is a fan of bright line rules. I think the mid-20th century jurisprudence was a fan of bright line rules, but a lot of those bright line rules have been proven to be economic nonsense. And the rolling back of those bright line rules, both by the Supreme Court and by lower courts, has, probably enhanced economic rationality.
Yeah, I'll add that I think it's an oversimplification. I mean, certainly the court has had pronouncements like Alice that have been sort of very difficult to untangle, and so I think it's fair to say that the court has sometimes introduced uncertainty, but I think the notion that the court has injected more uncertainty into the patent law than the Federal Circuit has in a number of different contexts is simply not true. And on the converse, I mean, at times the Federal Circuit, Octane as an example of this, has achieved certainty, making fees extremely difficult to achieve, or enhancements in patent infringement cases in Stryker extremely difficult to get, by grafting onto the statutory text a fairly complicated framework that can't be gotten from the text or the history. So I don't think the factual premise is accurate that the court has issued magisterial pronouncements while the Federal Circuit has been down doing the nuts and bolts and providing certainty to practitioners. And even to the extent that the factual premise is true, I think in some of the cases where the Federal Circuit's rules have produced more certainty than the court, they have done it at the expense of what the court at least has viewed as traditional tools of statutory interpretation. I'd say the same thing in Stryker, and we'll see if I'm right about that.
Yeah, I think it's a fair criticism, or maybe it's not a criticism, I think it's a fair observation to note that the Supreme Court takes a somewhat different approach to patent cases, at least in recent years, than it does, say, to something like the First Amendment, where it doesn't get much more, vague and amorphous than the First Amendment, but yet we have hundreds, thousands of pages of body of common law with developed doctrines and multi-factor tests for all sorts of things, and we distinguish between different types of speech and all sorts of stuff. That's the business of a common law court in our system, and the Supreme Court seems much more comfortable with having these rules in that area at least than it does in recent years in patent cases. But if there's something that explains that, I think it is the fact that the Supreme Court regards the body of First Amendment jurisprudence as its own, and having been created by itself and then evolved by itself. And the Supreme Court is simply not willing to outsource that job in any area of the law to any other court. And so I think, to answer a question that Jeff posed earlier, which is what was the change from when he clerked and when I clerked that made the Supreme Court more interested in taking more patent cases, I'm not certain exactly what was the thing that tripped the divide, but I do know that, by the time I got there, we clerks and I think, well, not clerks, justices, and clerks taking cues from their justices, did not think about affording particular deference to the Federal Circuit. It had been established that these are very important policy debates, and even for justices who regard patent rights as just like other forms of property rights, which is my sort of overall thesis, and view patent cases as subject to the same sort of litigation procedures as other types of federal cases, there is an awareness that there's a lot at stake in these issues, and there's too much at stake for the Supreme Court to not be able to pay attention, and especially by virtue of the fact that you don't see circuit splits in patent cases because all the cases go to the Federal Circuit. A decision like Alice, which is a sort of splintered decision from the Federal Circuit, is almost an automatic candidate for Supreme Court review. Because you have what is otherwise you don't have the normal circuit split process that you would get in those cases.
Well, I would rather open it up for question and answer.
Yeah,
I think we
have opportunity for you to ask any questions you may wish to pose to our expert panel here. Let's start with the gentleman.
Ilya Shapiro from the Cato Institute. Jeff, I didn't realize you're an IP expert now, my law school classmate.
I didn't either.
Yeah. When I talk to either practitioners or, I'm a simple constitutional lawyer, when I talk to either IP practitioners or academics, everyone's dissatisfied with both the Federal Circuit and the Supreme Court for different reasons that have come out in this discussion. And so I'm wondering if any of you, or to what extent you might agree with Judge Diane Wood's call to remove exclusive jurisdiction, at least over patents, from the Federal Circuit. Would it benefit either the interest of stability in the law, better public policy vis-a-vis innovation, or other interests to have percolation among other courts before the Supreme Court gets involved?
Well, I defer to John Duffy on this one.
So I wrote an article on that about 9 years ago, and with Craig Nard, Professor Craig Nard, and we did call for a return to a little bit more diversity of jurisdiction. Diane Wood actually cited our article, and her proposal was a little different than our proposal. Our central thesis was that in approaching the question of how many appellate courts should have jurisdiction over patent cases, Congress is fundamentally approaching an optimization problem. And that there's strong arguments for having fewer courts because the fewer courts will have more cases and become more expert. And there's arguments in favor of having more than one court, which is basically that you'll get diversity of opinion and get some degree of conflict on the more controversial doctrines, and that would be a signal to that there are different opinions. Our central thesis was that you have to optimize, and that maybe Diane Wood's proposal or Judge Wood's proposal, which was go back to 13 appellate courts that will have jurisdiction, is not as good as saying maybe have 3 or 4 appellate courts where you get many of the benefits of diversity of opinion, but you will still get some expertise. And one way to think about this is if you think about antitrust law again, and you say, sometimes many industries don't have, 20, 30, 40 competitors. Many times there's a smaller number of competitors, but you lose a lot when you go from 2 or 3 down to 1. That's basic economic, theory. So even though there's only 2 large aircraft manufacturers in the whole world, Airbus and Boeing, there's still some benefits from competition there. And that's why we thought that having a smaller number of appellate courts would be a good thing, and that it would actually produce percolation of ideas about the tough issues of patent law.
Can I just add on to that? I disagree with Jeff's claim earlier that is no difference between the kind of the splits and the panel differences you saw in the Federal Circuit when it went before the Supreme Court was weighing in, because the reality is that the Supreme Court took a break from weighing in on patent cases starting in the mid-1980s to give the Federal Circuit the space, the legitimate space and time to fulfill its statutory mandate to establish some national rules for the patent system. But that was an historical anomaly. The Supreme Court usually has been very active in the patent space before that period. So then when, during this period, it became common for patent lawyers to complain about the indeterminacy at the Federal Circuit and whatnot. That is completely empirically unverified. I mean, my response to those complaints is constantly, by what baseline, by what standard can you show that there's actually more uncertainty now than there was before with Federal Circuit panels? But I'll tell you something. When I talk to representatives from the high-tech industry, companies that rely upon patents, that's seen their patent the value of their patent portfolios collapse in the recent years, when I talk to people from the biotech space, when I talk to a representative from a major biopharmaceutical company who said after Mayo decision came down, they shut down a multi-billion-dollar personalized medicine line because they said, well, we can't get it patented anymore. So, we're not going to invest billions of dollars in this stuff anymore. I disagree with what I'm hearing from the innovation industries is there's substantial uncertainty about what is now protectable and what is not. And when you have that type of uncertainty, business persons put their money elsewhere. And you don't get the type of innovation that the patent system is intended to promote vis-a-vis other types of legal systems like trade secrecy and whatnot. And that is a demonstrable, I believe, a demonstrable fact that we're seeing in the innovation industries right now. And I think that follows from some of the Supreme Court decisions that have been handed down of late that are vague and unclear and have a tilt to them that can be read as being, for lack of a better term, anti-patent by judges and attorneys and policymakers who want to use them in that way.
Thank you, Adam. Can I ask you, do you think that's because, as Professor Duffy mentioned, the cases that have gone to the Supreme Court have just been so bad?
Yeah, there's certainly a selection effect here. I often hear from patent owners saying, "Oh, if we can only get a great patent before the Supreme Court, we won't have these problems." I said, that's the whole point. If it's a great patent, if it's solid and it's irrefutable and everyone agrees that it's novel and non-obvious and useful and it's patentable subject matter, it's not going to be litigated. The people will settle because the person that you're suing for infringement is going to settle. So the whole reason why you're getting these particular patents with these particular bad facts before the courts is because that's the selection bias that occurs in litigation, where there's space for the attorneys to make the arguments and to advance the policy case that they want to advance. Yeah.
Thank you. We have another questioner.
Yes, Judge Alden Abbott, Heritage Foundation. There is one case which I think suggests a potential concern about an anti-patent bias, and that's activists. When I think where after most circuits seem to buy into this idea of scope of the patent test for settlements, not reviewing antitrust settlements. There was an excellent dissent, by the way, by Chief Justice Roberts there. You have this very rambling opinion by Justice Breyer talking about balancing patent interests against antitrust interests, which is a strange way of talking about a property right, if you truly believe it is a property right. And it seems to me, I don't know if anyone's interested, but there's this huge literature, which I think is poorly based and not empirical, coming from Mark Lemley and Carl Shapiro on probabilistic patents, which has become very, very popular in certain circles. And does anyone want to comment on that? Because my concern is that this pseudo literature on patents is tending to weaken, may threaten to weaken patent rights in the future.
I kind of hear two questions, one on the Activin case and the other one on the literature. Comments?
Well, on the activist case, I'll say I do not think that is very anti-patent, because the mechanism that Congress used in that statute was a very unusual mechanism, which was basically to use litigation as a form of competition, which is very strange, and that they tried to create incentives for generic companies to challenge the validity of a patent. And remember, if a patent is not valid, it shouldn't give any exclusive rights. The economic theory of that and both the legal and law on that is clear, and the economic theory on that is clear. So Congress tried to create litigation that people would compete. And obviously, if people are supposed to compete in litigation or compete in any arena, and they basically say, listen, what I'll do is I'll cut you a deal. We don't compete, and I'll split the royalties with you. We'll split the market. That's sort of a fundamental antitrust violation. So once you view litigation as a form of competition, which in that particular statute, Congress did think of it in that way, then what is going on with the so-called reverse payments case is deeply troubling from a standpoint of antitrust law.
Just to respond real quickly, on the merits of activists, as a former law clerk to Chief Justice Roberts, I don't want to say anything about the case other than that the Chief Justice's dissent is excellent. But about on your question about the literature, what I think stood out to me is the fact that there are many cases, and there are many areas of law, and patents are one of them, where there is a very developed body of literature about the subject that goes totally unknown to the Supreme Court. The Supreme Court just does not, you can bet in almost every case that if there's a body of literature, they're not reading it. Sometimes that literature and that work, which is very sophisticated, gets to the court often through amicus briefs. But even then, amicus briefs are read anecdotally, selectively. They're more skimmed, I think, than read. And I can't speak, of course, for all justices or even the one that I clerked for all. But that's, that is my experience, and I think, Jeff, you can tell me if you disagree based on your experience working there. But these things the Supreme Court is too busy to be paying very much attention to a body of literature, and that disconnect is something that often does affect outcomes in litigation. And to the extent that advocates are able to effectively work in these empirical or propositions that get developed in the literature and really get the attention of justices, they oftentimes, that's how doctrines sometimes turn.
Now, I would agree with that they're not like immersing themselves in the patent antitrust nexus literature. But where I think I would disagree with you slightly is that some of the literature and issues that Alden was raising has driven a generalized policy debate and a generalized discussion about the patent system in DC within the Beltway and more broadly, where rhetorical epithets are now thrown around very loosely. Patent troll, it's even been used here. You will search in vain for an agreed upon definition of that term. It covers inventors, it covers universities, it covers IBM, it covers all sorts of legitimate companies. Yes, it covers some bad actors. There's bad actors in the patent system, but there's bad actors in contract systems. There's bad actors in every legal system. You have junk science statistical studies being pushed that show something negative about patents. So Mark Lemley asks 88 of his friends by sending out a general email inquiry. Well, when you were sued for patent infringement, did you innovate after you settled? And the answer is no. And then he'll write a paper. Does licensing lead to innovation? He says no, because 88 of my friends said no. I've proven it now. And these claims then seep into the policy debates, seep into the discussions, and get put on the front page of the New York Times, get front page of the Washington Post. Justices read that, and they start to get influenced by it. And then you start seeing these terms appear in their opinions. You start seeing some of the literature cited in their opinions. Mark Lemley's work is starting to be cited by Justice Thomas in some of his patent decisions in the Teva case, Teva v. Sandoz. Patent troll was used by Justice Scalia in last term. And so this is the concern. So this is the concern that the justices are picking up on and are going with this general moral panic that has been pushed in the policy debates about the patent system by a very interested group of stakeholders in the innovation economy who don't rely upon patents, who want to weaken patent rights because it advances their particular business interests and their business models that don't rely upon patents.
Thanks, Adam. And next question.
My question is about the interpretation and meaning of natural law.
What?
Natural law.
Natural law.
Natural law.
I am a PhD with a law background with an interest in biomarkers, and I like to give a little bit background from my question because some of the Supreme Court decisions have significant impact in the field of biomarkers, and my view is that biomarkers of disease was going to determine whether most of you live longer or die sooner, so it should be of some interest for all of you.
Diagnostics and patents and natural law. Why don't we take it from there? Thank you.
They should be
But,
clearly.
I want to clarify what the issue is. The issue that I want to make it is that the concept of natural law is not as clear as is indicated in the Supreme Court. Most issues of what people consider natural law, at least in medicine, from a scientific perspective, are not natural law, but are approximations. When we say that cholesterol is associated with heart disease, we don't mean that that's a natural law, but we mean it's an approximation.
Yeah, I think they understand.
We
I
understand,
think we
yes.
understand.
Yes, there's been a misuse and a misapplication of this concept that has been built through these court interpretations of the patent statutes over the past 150, 200 years. 100% agree that identification of correlations in a medical lab for the purposes of therapeutic treatments of patients is clearly the type of innovation that the patent system is intended to promote. It entails oftentimes tens of millions, if not hundreds of millions of dollars of R&D, as I detailed in my amicus brief in the Sequinom case, and the fact that the Supreme Court and the Federal Circuit now at a rate of 96% is saying that these types of innovations are not patentable is a serious, serious problem for our innovation economy and for the types of inventions that biochemists and others create in the biotech industry.
Thank you, sir, for your question. Next.
Thank you, Your Honor. My question is mostly to Professor Mossoff, but if anyone else wants to jump in, they can as well. You talked about patent trolls and how we have a lot of bad information that is now being used in different decisions. How can we shift back to, say, first maybe correct studies or like better definition of patent trolls, whether it be from academia side or just industry side?
Can I just add to that question? Things like royalty stacking and the whole tragedy of the anti-commons has absolutely no empirical support. How does that play into the gentleman's question?
Well, I think it's that for a long time, the people who held patents were secure in their property rights. The Federal Circuit was relatively pro-patent, and they didn't care about academics. They didn't try to build any kind of intellectual basis to support their property rights and sort of lay fallow. And the group that sort of wanted to storm the gates of the status quo, they actually paid attention to academics, and they really, I think, as Adam said, in some cases they really sort of tried to build ideas through a variety of techniques. And they were very successful at that. And even the Federal Circuit, I'll say, Judge Rader, I think, does, in writing opinions, pay attention to the academic literature. Many Federal Circuit judges will tell you, and proudly so, that they don't want to listen to academics. And so I think that the Federal Circuit itself, especially some of the judges who I think might be open to more pro-patent arguments, try to say we don't care about public policy. We only care about what the statutory language says. I've heard that from multiple judges. And I think that's not, that leaves the positions of the case law fundamentally weak. And therefore, then it gets reviewed by the Supreme Court, and it's fundamentally weak. It lacks an intellectual foundation. In the long run, academics matter. Shockingly enough. That's, yes. Of course, a completely, I'm not self-interested in that statement whatsoever.
So the hope is part of the problem is law professors, like lawyers, are we're not specialists in empirical research necessarily. Some lawyers and law professors have backgrounds in statistics and economics, but many do not. And law journals are published by law students. They're not published by people who have degrees in statistics and economics and whatnot. So part of the issue is to develop norms for good research, for data-driven, rigorous research that follows proper standards in empirical and statistical and economic research, right? I mean, can you imagine a doctor publishing a study saying, well, I interviewed 90 doctors and they told me that there's a disease out there that's a problem. I mean, that wouldn't appear in the New Journal of England of Medicine, but those types of studies appear in law journals all the time. And then they get pushed into the policy debates by lawyers doing their jobs as lawyers on behalf of their clients, as lawyers should, saying, look, there's now a proven problem. See the Cornell Law Review, or see the University of Chicago Law Review. I think what we have to develop is a better appreciation and understanding within the legal academy, and more generally for what is appropriate baselines for doing empirical research and making other types of claims.
I think our esteemed Federalist leader gets the final question here.
I'm going to turn it right back on you. We had an interesting discussion a few questions back about the role of the Federal Circuit and the role of the role of the Supreme Court, and some reasonably critical things said about both courts. But I thought with you here, if you were willing to, it would be interesting to get your perspective on that.
Agreed.
Agreed. 100%.
Second.
Agreed.
Well, I share the view that I don't think there's a hostility towards the court from the Supreme Court. I do think the Supreme Court has a degree of disconnect with another national appellate court controlling the entire realm of the subject matter given to it nationwide. And I think, remember, each of the justices came from a regional circuit where their concern was regionally developed and where they did look to conflicts, and that kind of a percolation policy was what they were comfortable with. And so they're uncomfortable with Congress's choice to create a second national appellate court that would have, in many senses, equal. And I remember having the most interesting conversation with my dearly departed friend that you worked for, Justice Scalia, and we were just alone, so I could be very honest, and I said, do what you want in Bilski. I'll handle 40 more of those cases before you get another one. And he laughed and he said that the Federal Circuit is a one-of-a-kind institution in the world. He's absolutely right. And I think that the historical basis for the creation of the Federal Circuit has been lost a little bit, and the Federal Circuit's uniqueness has been lost a little bit, and there is a desire of the Supreme Court to treat them like any other circuit when they aren't.
Interesting.
Do you want to comment on that? Do you want to
comment
on that?
Go. Yeah, I know.
So-
I've read your article 2 or 3 times, so I know what I'm going to
there's
get.
an earlier article I wrote that actually, which was 13 years ago, when I wrote the first article that said the return of the Supreme Court to the bar of patents, and it was highly controversial. Indeed, the year before, there was an article written by another friend of mine who said the age of the patent system in the age of the invisible Supreme Court. And my thesis was that the Supreme Court was coming back to the patent system, and that should be expected, actually, for the reason Adam said, which is now accepted, which is that historically they have had a large interest in the patent system. And at the close of that article, and I still believe this, I said the combination of a generalist Supreme Court and a specialized appellate court can function, or at least function effectively, only if the generalist acceptance of its limited competence is matched by the specialist court's acceptance of its limited authority. In other words, the combination can work if each institution practices the virtue of humility. And I think, unfortunately, judicial humility over the last decade, over the last dozen years, has been in short supply on both sides, I think. That I think is a problem.
I wish I'd said that.
Well said.
That's a lovely comment. If we don't have anything else, we'll make that our last comment.
Well, I would just like to say quickly one thing, which is that given the remarks about our esteemed late Justice Scalia, I'm very happy to announce that it was approved today by the Virginia State Higher Education Commission that the $30 million renaming donation has been officially accepted, and as of July 1st, I will be working at the Antonin Scalia Law School at George Mason. So, thank you.
Thank you very much, everyone. Thank you to our panelists. You did marvelously.
Thank you, Joe. Thank you. You made it in the nick of time.
I did.